QUARANTI versus Temple is the next case. I'm sorry? I don't care as long as you know which one is which.
Let's hope we've got that much figured out.
Normally the appellant sits over here and the appellee sits here, but we don't care. How much time do you want to reserve, counsel?
Your Honor, I would like 8 minutes reserved. I am Mark Cornelius. May it please the Court?
You may proceed, sir.
Thank you. I am Mark Cornelius from the law firm of Goldman, Lenz & Munz, here on behalf of Nicholas J. QUARANTI, the appellant here, the plaintiff below. And if the Court will forgive me, I am a trial lawyer at heart, and I will defer to the terms plaintiff and defendant. If I can try, I will try to stick with appellant and appellee or respondent. This case arose out of an auto accident.
Let me ask you this. What does the stipulation related to the medical medical expenses that says you stipulated that they were reasonable and related? What does that mean? I know what reasonable means. What does related mean?
Causally related to the accident, caused by the accident. That's
okay, so you were entitled to a directed verdict then for 83-23-52 then, right? Once the judge directed a verdict as to negligence, and you had a stipulation that $8,300 in bills were causally related, and that these were reasonable. I mean, there's no fact issue left for the jury, is there?
That is correct, Your Honor.
Okay, did y'all move for a directed verdict on that issue?
We did not. We are not.
Why not? I mean, don't you have to? I mean, shouldn't you do that?
Do we have to? No, we're not.
Why were the bills even submitted to the jury as an issue at that point?
They were submitted so the jury could help establish damages. I believe you're looking at the joint stipulated exhibit that shows that portion of the bills were stipulated as related.
Well, you got a goose egg in this case, right?
That is correct, Your Honor.
Yeah. All right. Now, so related is, I mean, you know, we're all lawyers here. Related, you know, is not really a legal word.
Related is a legal term of art used in automobile cases. It comes from 627.736, the Florida PIP statute, otherwise known as the Florida Motor Vehicle.
Yeah, but PIP is not a cause of action. Really, I don't think it's a cause of action for damages. It's the cause of action to recover insurance benefits. Your cause of action and tort has been taken away, but I don't even think that's a legitimate comparison. Really, the plain meaning of this is that you wanted to establish the amount so that you didn't have to determine whether the amount was reasonable. Isn't that basically what the stipulation was all about?
Not at all, Your Honor. It not only established the amount was reasonable, and the defendant was not arguing that at trial, it also established that the bills were related to the accident.
Well, can a bill be related to an accident and not legally caused by the accident?
No, Your Honor.
No?
Related is a term of art that is something that all trial lawyers in the state of Florida have become intimately familiar with because it is used in the PIP statute.
Where do you get that from? I've seen plenty of these, and related. Basically, what this is it's a stipulation as to the amount, and if the amount's reasonable, so you don't have to call the physician to say, yes, I spent so many hours, and this is reasonable, and that's reasonable, so you can do away with all that. Related means that that it's reasonable, related to the services that were rendered to the patient. It doesn't mean that it was caused by the accident.
Well, actually, with all due
Why
respect,
didn't you put the reasonable and caused by the accident then instead of related? Related to what?
because related is the term that we're used to, Your Honor, because that's the term we see. We do.
So you're saying that that is standard and customary practice in the bar to, you know, to stipulate to the reasonableness of the amount so you don't have to put on all that evidence and then you put reasonable and related and that automatically refers to causation?
Related is a separate term with meaning. If it had no meaning, what Your Honors would suggest it appears is that the term related in that document that's found at page 1170 of the record is without meaning, and that is not at all the intent of the
Reasonable and
document.
related to the care rendered to the patient doesn't necessarily mean that the injuries were caused by the accident that led to the services provided by the healthcare provider.
Well, the stipulation doesn't read
It doesn't
that.
say that. Doesn't it? It says reasonable and related. Related to what? Reasonable and related to the care provided by the service, by the healthcare
I
provider.
believe the stipulation says related to the accident.
It does? Okay, well, I have to take a look at
Copy
that.
of it.
Does that necessarily mean it's related to the accident, that the injuries were caused by the negligence of the tortfeasor?
Yes, especially under the facts that we have in this case. Would Your Honors like me to dispense with the facts? They're simple and straightforward. I don't need to go through them if Your Honors, you've asked me a question and I didn't get through the facts. The bottom line is we've tried this case in May of 2005. This was a rear-end accident.
Counsel, we're familiar with the facts in the case. I think you might serve yourself better by just sticking to the legal issues there. It seems to me that it might be possible that Temple was negligent, but not the legal cause of damages, particularly these medical expenses. If these were totally unrelated to the accident or not caused by the accident, and the jury found that way, then it doesn't seem to me like you could recover for them, could you?
I agree, if that was in fact the issue. What the jury was asked was the negligence of Robert Temple a legal cause of loss, injury, or damage?
And they said no.
And they said no. And
At the end of it, then.
that is not the end of it, Your Honor, because the jury, despite the fact that plaintiff never moved for a directed verdict at the trial level, the jury still has a duty to return a verdict that comports with the evidence. Now, the plaintiff has a very high standard here. It is a standard which I have, in 11 years of doing this, maybe more, never seen a case that truly compels Your Honors to find.
Well, did you tell the jury that they stipulated that, you know, that the medical expenses were reasonable and caused by the negligence of the tortfeasor, and, you know, instead of just saying related to the accident?
I'm not sure I understand your
Well,
question.
I think there's a difference in that the expenses being related to the accident, because, you know, oftentimes there's comparative negligence and that sort of thing. So who knows, you know, what caused what. I think there's a difference in saying that it's related to the accident, and you say that that's what the stipulation says. And I think there's a difference in saying it was caused by the negligence of the tortfeasor. And my question to you was the jury told that we had a stipulation that, you know, by the other side, that these medical expenses were caused by the negligence of the tortfeasor?
I don't want to misstate to the court. I believe they were. Unfortunately, we do not have a complete record. So
The jury was instructed as to that?
Oh, instructed. Now, you asked if I told them that, whether it was argued in closing. I believe it was.
Did you tell them?
They instructed you for that.
You argued that to them as well?
I believe that was a closing argument, because they had the evidence in front of them. And that's the key to this case. This is a case where Your Honors not only have to find, or not find necessarily that the verdict was contrary to the manifest weight of the evidence. That was, of course, the standard for the trial judge was
Okay,
presumed.
then what happens when you argue that to the jury and there is a stipulation and the stipulation is admitted in evidence and it's argued to the jury and they just disregard it and say, well, there's no causation anyway?
If in
That's
fact,
what we have here.
if in fact they disregarded the jury verdict, we have no evidence of that.
Well, they disregarded the stipulation. The stipulation is evidence. You're saying that, you know, we argued that there's a stipulation and they say, you know, that this was caused by the accident and caused by the negligence of the tortfeasor. And, you know, let's assume that the stipulation is admitted in evidence and the jury considers it and then they just throw it out and reject it. Then what?
Then you have to look to see if there's any conflicting evidence. And under this court's decision in DeWitt versus Freeman, which is a 5th BCA case at 77709. It's cited in the briefs. And I cite to it because it has our standard here. It's very important for us to understand what our standard is. As I said, the trial court had to determine whether the verdict was contrary to the manifest weight of the evidence. I'm going to show Your Honors that not only was it contrary to the manifest weight of the evidence, it was contrary to all the evidence. In addition to that, the DeWitt court went on to say, okay, now, that may have been his standard, but we have to find an abuse of discretion in order to overturn his denial of the motion for new trial. And in doing so, they defined it a little clearer for us, because an abuse of discretion standard is the highest standard.
Counsel, let me ask you this. Could the trial judge have granted an additor or granted a directed verdict for the $8,323.52?
Yes, he could have, had the motion been made.
Would you have had an appellate remedy at that point if the trial judge had granted your motion to the extent that he entered judgment for $8,323.52, notwithstanding the verdict of the jury?
Had he done so, our motion or our appeal would be much weaker, because there then would be damages awarded by the court, even though not by the jury. And I think, though I must admit I'm not up on the remurder case law, I think what the trial court would have had to do was give us the option of taking the additor, or a new trial. I believe that's what the case law reads, but I don't want to hold that I'm an expert on that, and I know that law.
Counsel, was the jury instructed on the legal meaning of the word causation? Isn't that a standard jury instruction that they get?
I believe it is, Your Honor. And
is there any instruction given on the meaning of the word related?
I do not believe so, Your Honor, but it was certainly argued and explained. But even assuming, let's assume, because the bench at this time appears to be having difficulty with the stipulation, let me talk about the other evidence that was presented on whether or not there were damages sustained as a result of the accident of August 25, 2000.
Well, you had an ambulance ride.
He had an ambulance ride.
I mean, there's no reasonable argument that can be made that that wasn't causally related to the negligence, right?
Right.
$470, and you had an ER, I guess you had a charge. All those 825 charges are from the emergency room, right?
I believe so.
Okay.
Yes, they are, Your Honor.
So, I'm going to really want to hear from the appellee why they're not legally caused by the negligence of the appellee.
I can tell you what they've argued in their brief and respond to it, or I can wait for rebuttal. I'm not sure if you're inviting me to respond to their brief, Your Honor.
I'm just giving the appellee a heads up that that's going to be my first question for
Fair
you.
enough. I'd like to
Wait a minute, are you saying that simply because these charges were incurred and there was an ambulance that came and picked your client up, that automatically means that the injuries were caused by the negligent act of the tortfeasor?
Under the facts as we have them in this case, as presented to the jury in May of 2005, the answer is clearly yes, Your Honor.
What about then any other charge? We could say, well, there's this charge and there's this other charge, and because these charges were incurred, that they were caused by the accident?
Yes, Your Honor.
Counsel, you had several other medical charges that you were trying to recover in that, by virtue of that stipulation, and you had medical testimony from 3 different people that the cause was related to the accident or caused by the accident. And then there was one witness, an expert witness on the other side, who said no, they weren't, that these were related to pre-existing conditions or whatever testimony was. Isn't it possible that the jury simply ignored your 3 witnesses and relied on the expert for the other side and concluded that, well, that the man has some problems, but they're not caused by the accident itself?
If I may, Your Honor, I'm going to reply to that in 2 parts. First, I'm going to point out that it is not preserved on appeal because Appellee has not raised in its brief any facts that would show, contrary to the point argued by appellant.
Well, the appellee doesn't have to, the burden is on you to raise it as an issue. It's not on the appellee to raise it as an issue. That's
correct. We raised it as an issue, and they've pointed out no facts that would suggest, as Your Honor is suggesting, that the doctor testified as such. In fact, in our brief, we've cited to testimony, and in the record, it clearly states, as a matter of fact, there's 2 doctors that testified for appellant. One was a Dr. Halpern, and Dr. Halpern admitted that, in fact, the plaintiff was injured in the auto accident of August 25, 2003, aches and pains. He didn't want to get, of course, his job is to not, overstate it, but he didn't understate it either. He clearly admitted that there was injury. In addition to that, there was a doctor that they put on through video. His name is Dr. Gary Weiss, a chiropractor. He was an examiner for PIP, and he also stated that there were injuries that were reasonable, related, and necessary to treatment. That was reasonable, related, and necessary to this accident. The standard that your honors must find, and it's key, Judge Ployce, that you pointed out that evidence, because under the DeWitt decision, you must find that the evidence was clear and obvious and not conflicting. If you find conflicting evidence, you must find against the appellant. However, in this case, there is not conflicting evidence. No conflicting evidence has been argued by the appellee in its brief because none exists. At this time, your honors, I'd like to reserve the remaining 5 minutes and 40 seconds or thereabout for my rebuttal. Of course, the appellant asked you to reverse the trial court's denial of our motion for new trial and demand a new trial upon the percentage of negligence attributable to each party and the damages suffered by Mr. Quaranti.
Thank you. Yeah, hang on just a minute here. Let me get you. Okay, Counsel, you can begin.
Thank you. My name is Sean McDonough. I represent Robert Temple.
I didn't catch your name. What was that again?
I'm sorry, Sean McDonough.
Okay. Mr. McDonough, Dr. Halperin was your client's orthopedic expert, right?
That is correct.
Now, he said that the plaintiff had an arthritic back pre-accident, right?
That is correct.
And he also said that as a result of the accident that I think he's got an arthritic back and he had an accident that the doctor had no doubt that the plaintiff hurt for a while after the accident as a result of that, right?
Correct.
Okay, now why isn't the ambulance, in other words, your client, caused an accident, this man's there in pain from his arthritic back at the scene of the accident, why is not the ambulance expense, irrespective of whether or not it was a, permanent injury, why isn't the ambulance expense causally related to the negligence of your client?
Because the jury did not find that Mr. Temple's negligence caused the accident. It's not really about the damages in this case. It is about the cause that the jury was given the opportunity to determine whether Mr. Temple's negligence was a cause of the accident. Now, I understand the puzzled look on your face is, wait a second, if Judge Bronson decided that
there's negligence, there's duty, and there's breach of duty. So the judge directed a verdict on duty and breach of duty. Okay. Now the instruction was whether the duty and breach of duty, whether the negligence was the legal cause of loss, injury, or damages.
That's correct.
Yeah, I mean, your client breached a duty, there was a wreck, and this fellow's got to be hauled off to the ambulance. How can any jury not award at least that expense?
Because I think our argument is that even though Judge Bronson found that there was negligence, and as lawyers, we know about the presumption of negligence, and that would encompass some type of cause of the accident. The jury was never instructed on that. The jury was given an opportunity to decide whether that negligence, people are negligent when they drive every day. It doesn't necessarily cause an accident. Even if it did cause, even if there was an accident and there wasn't...
Really, the gist of it is that in order to recover damages, those damages have to be caused by the negligence of the tortfeasor. But for the tortfeasor's negligence, these damages would not have occurred. So if we say that the ambulance ride is a measure of damages that they're seeking compensation for, if the jury says it wasn't caused by the accident, they're not entitled to that. Is that basically correct?
That is correct.
What evidence do you have? They said that there's no evidence in the record that contradicts. Basically, they're saying that the evidence is uncontradicted, that that the accident occurred and that these damages and these injuries were caused by the negligence of the tortfeasor, and that you put on absolutely no evidence, and there's nothing in the record that contradicts that. That's their argument. So tell me, what evidence do you have in the record that indicates that these damages were not caused by the negligence of the tortfeasor?
Well, and I have two different issues there with causation. Causation of the accident, as well as
I'm talking about
accident
causation.
causing the damage.
I'm talking about causation of damages, because that's what we're talking about. They're basically said this was a rear-end collision, so there's some negligence. Even though there's negligence, the damages have to be caused by that negligence. So I'm talking about causation here, causation of the damages. What evidence did you put on to counter their evidence that all of this was in fact caused, all of these damages were in fact caused by the negligence of the tortfeasor?
Well, as Judge Boyce pointed out, there was at least one defendant's expert that indicated that the damages were not related to, that the injuries were not related to the accident.
What's the name?
That I believe that was Dr. Weiss's testimony.
I'm sorry, what?
Dr. Weiss.
Still didn't hear you.
Dr. Weiss.
White.
Gary
Right,
Weiss.
okay.
And
What did Dr. White testify to? What did he say?
well, I believe that he also, I believe that he said that they were not related to, that his injuries were related to a pre-existing condition and not related to this accident. My only concern is
Dr. Weiss's
That testimony is not included in the record, by the way.
and it's not included in, and I guess it's my problem here is my
It's not in
argument
the
is
record.
not related to the damages. My argument is related to causation of the accident. Judge Bronson and plaintiffs allowing the verdict form to be as it was in the jury instruction.
Wait a minute, hold on just a minute. That's already been established. The cause of the accident's already been established. Causation, proximate causation, has to do with whether the negligence of the tortfeasor caused the damages. And so if this was a rear-end collision and the trial court ruled that, that your client was negligent, then the only issue is causation of the damages.
But the jury wasn't instructed on that. And the jury was instructed as to causation, that I think a jury reasonably could get from these jury instructions as to whether the accident was caused by that negligence. And especially since
you and I have a different understanding of approximate causation in a negligence cases, because number one, you established that a negligent act occurred, and number two, you established a breach of the standard of care, and number three, once you establish that, then you get to whether the breach of that standard of care was the proximate cause of the damages. If the damages weren't caused by the breach of that standard of care, you get zero. Do you understand that? I mean, is that?
I do, but I'm looking at the Coca versus Smith case, which is
This was a rear-end collision case. Judge Bronson granted a directed verdict based on the presumption, right?
and I'm saying that the error that occurred that was objected to was the jury was provided the opportunity to decide, all right, Mr. Temple's negligent, but we still need to determine Mr. QUARANTI's negligence and then decide whose negligence was a cause of this accident. And so if the jury sat back and went, you know what, I know maybe Mr. Temple was negligent because the court told me that, but the court gave me an opportunity to...
Okay, what were the percentages? What was the percentage of comparative and what was the percentage of the negligence of the tortfeasor? Were there any? Did the jury assign anything to comparative negligence?
No, because it stopped at question one. It decided there was no causation, and so it needed not go any further.
Well, counsel, you're making a entirely different argument than I thought you had made, in your brief. I thought you were arguing that the jury still was privileged to decide that he wasn't hurt, and I thought that was a pretty valid argument, that the jury could decide he wasn't hurt as a result of the accident and reject, all the claims of damages.
Well, I make both of those arguments, Your Honor, because there are, I think the jury sat back, you can get into the province of the jury, but once you get into the province of the jury, you can't
Okay, then what evidence is there in the record to contradict or to tell us that that these damages, these injuries were caused by the negligence of the tortfeasor? What evidence is there in the record that we can look at and say, okay, here it is? And this is, then we can say, well, this is what the jury considered, and therefore they rejected their evidence and relied on yours. Where is that in the record?
The record is Mr. Temple's testimony, and I know we're going back and forth on damages and
just restrict it to causation of damages only.
Whether the accident caused the damages. I believe that
whether the negligence of the tortfeasor caused the damages.
Well, I think the jury very well you can infer.
But where is the evidence in the record that did you put on any evidence as to causation of damages and injuries and that sort of thing?
And the evidence I put on was that Mr. QUARANTI was fully responsible for this accident.
But that
I don't. As far as evidence of injuries caused by the accident, I do have expert testimony, and I don't have it here with me now. And quite frankly, I'm not sure. I thought that they.
All right. Let me put it to you this way: when there's a rear-end collision and there's a presumption of negligence, and the presumption is not overcome, that establishes that number one, there was a negligent act, and number two, that the tortfeasor breached the standard of care. That does not have anything to do with whether the breach of the standard of care actually caused the injuries that occurred in the accident. You can have a breach of the standard of care and a person can be negligent all they want to, unless that negligence causes the damages or causes the injuries, you have no recovery. So in this particular case, there was a rear-end collision. Let's assume that the presumption of negligence was not overcome. That means that there's a presumption of liability in terms of breach of the standard of care. Then you have to establish that that breach of the standard of care caused the damages.
I believe the jury, with regard to
you don't have any evidence,
did not believe that he was hurt from that accident, that he did not need to go to the hospital.
That's the only way they could arrive at the verdict they did.
That's correct. Unless, and please don't mistake my confusion about causation with not knowing what we're saying here.
Let me ask you a question, okay? Let's just assume that the effect, because I don't want to argue with you over this, let me ask you to assume that the effect of the judge's ruling was that your client was legally responsible for the accident, okay? And then the jury was asked to determine whether there was causation of any injuries, damages, or losses arising from the accident. Okay, you with me so far? Okay. How can you argue, or I want to hear your argument, as to how the ambulance ride to the hospital is not a loss? It may, there may not be any injury. How is that not a loss that was causally related to this accident?
In this trial, there was multiple evidence of Mr. QUARANTI not being credible at all, and I believe the jury, with regard to the damages.
So he wasn't injured at all. He didn't feel any pain, and he took an ambulance ride just to set up a claim here.
Yes, and I think the jury can infer that from the claim.
Even though your client said that he had a pre-existing arthritic condition, and no doubt this accident caused him pain, and as a result of the impact.
And I think what you get there is you have a doctor on the stand who's saying, I'm not here to be a trier of fact and dispute whether he was hurt or not. It is possible he could have been hurt in this type of accident, even with a pre-existing condition. But an expert's not going to say.
What evidence, other than just pure speculation by the jury, what evidence is in the record that the plaintiff, at the time of the accident, just feigned an injury in order to get an ambulance drive for the thrill of having the lights and siren on while he was going to the emergency room? Well, I mean, we deal with evidence here, not conjecture. And tell us where in the record that evidence is.
There was multiple evidence throughout the trial. In hindsight,
that doesn't help me, counsel.
I know, because I did not. There's certain parts of the trial testimony that is not in the record. However,
That doesn't help us either. In other words, their job is to give us the portions of the record they think are important, and then you have the opportunity to give us portions of the record that you think are important. But you know, if the record's not before us, there's not a whole lot we can do about that. You can only quote from the record.
Well, having not anticipated your line of questioning, I did not place into the record perhaps all the testimony throughout the case in which Mr. QUARANTI was not truthful whatsoever from the very inception of the case. If it's helpful in this,
Do you concede that a bill from an ambulance is compensable, even if it proves out when somebody gets to the emergency room that you know they haven't got any permanent injury? Isn't it reasonable for somebody to, you know, when they have pain, you know, they've been in an accident, to go to the emergency room via ambulance? I mean, isn't that kind of a routine thing to do? How can a jury deny, in this case, how can a jury deny, you know, the recovery of that expense?
Because they did not believe that Mr. QUARANTI was hurt in the accident, and they don't believe that they even believe that Mr. QUARANTI's negligence was the sole cause of the accident.
Now, what about the stipulation that said that the ambulance bill was reasonable and related? What did that mean?
Exactly what was brought out on appellant's argument is that I'm trying to streamline the trial. I have no doubt that the ambulance personnel provided reasonable care, and that the care the care that was provided was related to the services they were rendering. I certainly didn't have any intention on stipulating that there was a cause of this.
What did the stipulation say? Did it say reasonable and related to the accident?
In hindsight, not having it with me right now, Your Honor, I'm not sure exactly what it said.
That is what it said.
Reasonably related to the accident.
Why isn't the jury bound by that?
I think the jury, after reviewing all the testimony, decided that he wasn't hurt, and that he did not need an ambulance ride. I also think that the jury felt that Mr. QUARANTI's negligence was the sole cause of the accident.
But you all didn't appeal that ruling by Judge Bronson,
I
right?
didn't have to because the plaintiffs did not object to the jury instructions to the jury and to the verdict form that gave the jury the opportunity to decide that Mr. QUARANTI was the sole cause of the accident. And after the jury was discharged and appellant had not raised any objection, they had waived any objection to a improper jury verdict form or jury instructions that allowed the jury to determine whether Mr. QUARANTI's negligence was the sole cause of the accident. And again, we get back to this presumption of negligence. I don't have any doubt that perhaps after Judge Bronson changed his mind and granted a directed verdict, that the first question should, in hindsight, should not have been, was Mr. Temple's negligence the cause of the accident, of any injury? It should have moved right to the second question of whether Mr. QUARANTI's negligence was a cause of the accident. But that's not what was presented to the jury. The jury didn't do anything inconsistent with what it believed the evidence showed in this case. If it either believed that Mr. QUARANTI wasn't hurt and didn't need an ambulance ride, and disregarded our stipulation, or that Mr. QUARANTI's negligence himself of jockeying for position as you're coming up to the light was the sole cause of the accident, and thus his damages were his own fault. And if we go into and try to figure out what the jury did, that's improper. It's not. You can't figure out what the jury did with that, and we shouldn't try to assume how the jury came to its conclusion. They were not. If the jury instruction and the verdict form, if their decision was inconsistent with the verdict form and the jury instructions, appellant never raised that objection and gave Judge Bronson an opportunity to bring the jury back and fix that error and give them a another instruction about, say, no, I've already determined that he's the cause of the accident. I now want you to determine whether whether the accident was the cause of the damages.
Well, there's a difference between a verdict which is internally inconsistent and a verdict which is against the manifest way of the evidence. Isn't there a difference?
Yes, there is.
One's correctable, the other one's not. If the jury just ignores the evidence and renders a verdict that is against the manifest way of the evidence, the judge can't say, okay, your verdict is wrong, go back and deliberate some more, right?
Well, actually, well, yes. Given the verdict form that we had here, either you found an inconsistency between the verdict and the instructions provided. That is fixable. You're right. And if it's inadequate,
No, it's not an inconsistency between the verdict and the instructions. It's those cases that deal with inconsistency deal with an internal inconsistency in the verdict. At some point in time, they found one thing, and then at a later time, they made a finding that was inconsistent with their first one.
Well,
That's an inconsistent verdict, right?
I would direct you to Coker versus Smith. That I was surprised when I found the case. You always try to find a case on all fours, and this was on all fours. And it talks about inadequate verdict, which is the case of it's against the manifest way of the evidence, and it also talks about an inconsistent verdict. The defendant in that case was talking about, again, rear-end situation, a situation in which the judge granted a directed verdict on presumption of negligence, and the jury was provided the same exact verdict form as we had in this case, same exact jury instructions on causation, and in that case, the jury came back and says the defendant was not a legal cause of the injury or damages, and the plaintiff argued that the argument was that there was an inconsistent verdict because the judge had granted a directed verdict on presumption of negligence, and yet the jury found no causation.
Counsel, your time.
Okay, thank you.
Yeah, about 5 minutes and 30 seconds, Counsel.
Thank you, Your Honor. May it please the Court. Appellee states we should have gone right to the second question. The evidence supported that.
Let me ask you this question. Let's assume that we say that the jury was right. There's no proximate causation established here. And you and I understand proximate causation to mean that the negligent act of the tortfeasor caused the injuries or damages.
Correct, Your Honor.
All right. And I want to get to this issue about the ambulance ride. That's a measure of damages, isn't it?
It is.
All right. And if the jury finds that there's no proximate causation here and that none of the damages were caused by the negligent act of the tortfeasor, you're not entitled to recover anything, are you? And that includes the ambulance ride, correct? Otherwise, what you're going to be telling me is that we should issue an opinion that says that every time you prove negligence and breach of the standard of care, you are entitled to a directed verdict every time that person gets in the ambulance and goes to the hospital.
As long as there's no conflicting evidence.
I'm saying that let's assume for the purposes of argument that the jury returned a verdict of no causation, and we say that was proper. Does the fact that there was negligence and the fact that there was a breach of the standard of care automatically entitle you to recover your ambulance ride?
Under the facts as presented in this case.
No.
This is a very unusual case.
No.
In every case, no, Your Honor.
Okay.
Because in most cases that I try, there's somebody over here, a doctor usually hired by the defendant, that says,
Okay.
he's not hurt at all.
Do you and I agree then that an ambulance ride is a measure of damages, that it's the burden to establish that that measure of damages, that amount, that damage was approximately caused by the negligent act of the tortfeasor? And that you have to get past step 1, negligence, step 2, breach of the standard of care, and get to step 3 and get past step 3 before you can recover that ambulance ride.
Agreed.
Right.
And there was a stipulation that allowed that, as stated by defense counsel or appellee in this case. Appellee made reference to COCA. I pronounce it differently, but in respect for this court, I won't.
We know which one you're talking about.
Okay. It's really the only case of substance, and it is very similar to our case. It is distinguishable on 3 key points. And the key point I would direct your honors to, and if you want me to shut up about this, I can if it's not of importance to you, but if the court at all is inclined to find this an analogous case, I think the distinguished points that I have are very important. I would direct your attention on page 331 of the published opinion to the paragraph immediately following Head Note 6 and immediately preceding what's marked as Head Note 7. And in that paragraph, the court sets forth its real ruling. It says, wait a minute, Smith's actual argument here is that the jury instructions and the verdict form are inconsistent with the trial court's directed verdict. It goes on to say that in that case, the trial judge, granted not a motion for directed verdict on negligence, as in the case at Lawler, but a motion for directed verdict on liability. And then Smith's counsel allowed the jury instructions, as opposing counsel has pointed out, similar to what we had here, and a verdict form similar to what we had here. We did not have a directed verdict on liability. There was no inconsistency between the judge's directed verdict and the jury instructions or the verdict form, which is why we have not made any argument as to whether they were inconsistent. We had no objection to make at the time, absent having, as Judge Schwartby inferred we could have, made a motion for directed verdict on liability. We didn't, but the jury is still required to follow the law. The jury still has to listen to all the evidence. And despite intensive questioning by your honors, there is no evidence to suggest, and I think Appellee finally admits it when he says we should have gone on to question 2, to suggest that there weren't damages suffered. The negligence directed verdict simply found very clearly for the jury that Mr. Temple's negligence was a cause of the accident. If then there is evidence to support, uncontradicted, not conflicting, clear and obvious evidence, as we have in this case, to support that there were damages, they have to answer question 1, yes. We can't assume, as defense counsel would appear that we should, that they didn't follow the court's instructions when we have another obvious explanation, which is they ignored the evidence, and therefore, your honors have to find that there was an abuse of discretion in denying the motion for directed verdict because it was against all the evidence that was presented. To the extent that appellant or appellee has raised issues regarding Mr. QUARANTI's testimony that's not part of the record, I'm not prepared to respond to that.
You don't want to get into that. If it's not in the record, please.
Unless you have further questions, I'm done.
Thank you, counsel.
Thank you.